You're listening to the Bloomberg Law Podcast. Catch us weekdays at 10 p.m. Eastern on Bloomberg.com, the iHeartRadio app, and the Bloomberg Business app. Or listen on demand wherever you get your podcasts.
Welcome to the Bloomberg Law Show. I'm Greg Storr.
And I'm Lydia Wheeler. We're filling in for June Grasso, who's out this week.
Ahead in this hour, we'll talk about a case that asks the U.S. Supreme Court to decide if Congress has the authority to tax foreign earnings. The case is being closely watched for its potential to stop Congress from creating a future wealth tax.
But first, a federal appeals court issued a ruling recently that seemed to gut the Voting Rights Act, or at least a key section of it. Joining us now to explain it all is Carolyn Shapiro, co-director of the Chicago-Kent College of Law Institute on the Supreme Court. So, Carolyn, tell us what the Eighth Circuit Court of Appeals did here.
The Eighth Circuit said that the Voting Rights Act of 1965 cannot be enforced by private litigants, that the only way it can be enforced, and in particular the most operative part today, which is Section 2, can only be enforced by the federal government. That's a really remarkable, dramatic, and just really unwarranted holding. People have been litigating Section 2 cases for decades, and it's sort of true that there's no express Supreme Court opinion that says in so many words there's a private right of action under Section 2, but that's because it's been clear for so long that there's a private right of action under Section 2. In fact, it's been so clear for so long that Congress keeps reenacting the law on that assumption. It would be just an incredible upheaval of voting rights litigation and law if this is allowed to stand.
Can you just remind us and our listeners what the Voting Rights Act does, and in particular what Section 2 does? So
the Voting Rights Act of 1965 is the law that basically made the 15th Amendment, which allowed African Americans to vote, made it effective. The 15th Amendment, of course, was a Reconstruction-era amendment shortly after the Civil War. And then for many, many decades, it was largely ineffective. States in the South found ways to make it impossible or difficult for African Americans to vote, and the courts basically allowed that to happen, including the Supreme Court. In 1965, Congress enacted the Voting Rights Act, and that really changed everything. It made our country the multiracial democracy that we purport to be. So it's an incredibly important piece of legislation. People often refer to it as the crown jewel of the civil rights movement. Section 2 of the Voting Rights Act provides that where there's a practice or a set of policies that make it difficult for a group of minority voters to elect the representatives of their choice comparably to the way white voters can, that can violate the statute. So, for example, if redistricting is done in such a way so that African Americans can't elect their favored representatives, that can violate Section 2 of the Voting Rights Act. It doesn't require intentional discrimination. It looks to the effects of certain types of decisions that states and local governments make about voting. It's been very important for many years, but it's even more important than it used to be because in 2013, the Supreme Court made the other most significant part of the Voting Rights Act inoperative, which is Section 5, the part that required certain jurisdictions to get approval before they made changes in their voting systems.
Can you back up a little bit for us and explain how this case came about? I know it was a lawsuit brought by voters in Arkansas. Is that right?
Yeah, this is an Arkansas case, and the district court in Arkansas, I believe, said that it found that there was no private right of action under Section 2 of the 14th Amendment, and it reached that decision, if I'm remembering correctly, even without the state having raised the question. It reached it of its own accord. claiming that it was a jurisdictional question and that therefore it was required to consider that. This is a really remarkable overreach. I can't emphasize that enough.
Tell us about the Eighth Circuit decision and the reasoning there. Why did they say there was no ability for private litigants?
They looked at the language of the statute, and they looked at the language of the statute in extremely isolated detail. And it is true, the language of the statute doesn't contain the words private right of action, and the language of the statute doesn't say in so many words that private individuals can sue under the statute. There are many, many statutes like that in the federal legislation. And historically, the court used to be somewhat more open to inferring a private right of action into particular statutes than it has become in more recent years. However, it has also said that where it's been clear that there's a private right of action in the past, that had been inferred in the past, and in particular where Congress has reenacted the statute, the court shouldn't go back and reparse the language of the statute under standards that did not exist when it was originally enacted. So it looked, what the Eighth Circuit did is to look at the words of the statute in complete isolation of how the statute has been applied for decades, and in complete isolation of the legislative history of reenactment of the statute, where it is extremely clear that Congress intended for people to be able to bring lawsuits to enforce Section 2.
What exactly is the state arguing in this case?
The state is arguing that they just can't be sued unless they're being sued by the federal government, which basically means that if the federal government doesn't have the resources or the ability, or depending on the administration, the desire to enforce the Voting Rights Act, the Voting Rights Act doesn't get enforced. They're saying that a private person or a private individual, such as the NAACP or individual voters or a community organization, just simply can't do anything about it, regardless of how blatant the violation of their voting rights are.
You know, Carolyn, one thing that struck me about this decision is that, reading parts of it at least, there was a congressional report from, I think, the House and Senate Judiciary Committees that said, we understand this law to allow for private lawsuits. Is this one of these cases where the legislative history, what Congress intended and was talking about, says one thing, but the language of the statute, at least arguably, says something else?
Well, I think that's how the Eighth Circuit interpreted the statute, or chose to interpret the statute. But I think that is a real triumph of form over substance. The statute itself doesn't expressly say one way or the other whether there's a private right of action. It certainly doesn't prohibit there from being one. And historically, it's been appropriate for courts to infer a private right of action. The court has, in recent years, changed that approach, but the Congress that enacted the law before Congress changed that approach, of course, didn't know that was going to happen. They were operating on the assumption that people have been suing to enforce the Voting Rights Act for a long time and would continue to do so, and we'll say that in our explanation of our reenactment of the law. I would not say that the law says one thing and the legislative history says another, but that is at least in part how the Eighth Circuit tries to defend its position.
Well, coming up on the program, we'll dive deeper into the recent voting rights ruling out of the Eighth Circuit Court of Appeals with Carolyn Shapiro. Remember, you can always get the latest legal news by listening to Bloomberg Law Podcast on Apple, Spotify, or wherever it is you get your podcasts. I'm Lydia Wheeler.
And I'm Greg Storr. This is Bloomberg.
You're listening to the Bloomberg Law Podcast. Catch the program weekdays at 10 p.m. Eastern on Bloomberg Radio, the TuneIn app, Bloomberg.com, and the Bloomberg Business app. You can also listen live on Amazon Alexa from our flagship New York station. Just say, Alexa, play Bloomberg 1130.
I'm Lydia Wheeler.
And I'm Greg Storr, in for June Grasso. We've been speaking with Carolyn Shapiro of Chicago-Kent College of Law about a recent ruling out of the 8th U.S. Circuit Court of Appeals on the Voting Rights Act. So, Carolyn, we've talked a lot about this ruling coming out of the 8th Circuit, a very conservative appeals court. There was a Supreme Court decision a couple years ago that perhaps laid the groundwork for this, a concurring opinion by Justice Neil Gorsuch. Can you tell us a little bit about that?
Yeah, so this is a case called Brnovich that came out of Arizona. And in this case, it was a Section 2 lawsuit that challenged a number of practices in Arizona having to do with the ability for people to use mail-in ballots and things like that. It was what's called a vote denial claim as opposed to vote dilution, so it didn't have to do with redistricting. It had to do with other practices. And the Supreme Court read Section 2 in that context fairly narrowly, but did not address the question of whether there's a private right of action. And, in fact, that wasn't presented. And Justice Gorsuch wrote a concurrence in which, joined by Justice Thomas, in that concurrence he said, nobody's raised this question, but it's been a sort of a question that other courts have asked in the past. And he cited a district court opinion from the 1980s as his example of why this remains an open question, which is, I have to say, not, in my view, very persuasive. But he put it out there for litigants to pick up, and of course they did. That's why he did it, and people who read Supreme Court opinions are looking for those kinds of invitations. So both courts, as in the district court in this Arkansas case, and the litigants in the Arkansas case and in other cases now as well, are starting to make that argument and to say, hey, this is an open question. Maybe there's no private right of action, and pushing the appeals courts to make rulings on that question.
So, Carolyn, we talked about how the 8th Circuit Court of Appeals here ruled there's no private right of action for litigants to come and sue to enforce Section 2 of the Voting Rights Act. But the New Orleans-based 5th Circuit Court of Appeals issued a ruling recently on this, too. What did that court say?
That court said that there is a private right of action. It didn't do a super deep dive into the statute of quite the same sort that the 8th Circuit did. It sort of parsing the language the way the 8th Circuit did, but it basically said, there's always been a private right of action here, and we don't think that there's a basis for changing that in this moment. That's the law of our circuit, and that's the law we're going to apply.
Carolyn, some listeners may be thinking that there was this case out of Alabama in the Supreme Court in its last term, and that was a lawsuit brought by private litigants, and the Supreme Court did something pretty significant in rejecting a Republican-drawn congressional map there. So can you explain how it can be, if there is an explanation, that the Supreme Court keeps acting like there is a private right of action, and yet this issue apparently is open enough that a federal appeals court decided that there is no private right of action?
Well, I would dispute that it really is an open question, in part for exactly the reason that you say. Everybody has assumed, and assumed is maybe the wrong word. It's an established feature of the law, and Congress itself has assumed that there's a private right of action in its reenactment of the law repeatedly. But it's because it is the case that there is not an opinion that says in so many words there is a private right of action, and you have Justice Gorsuch issuing this invitation, joined by Justice Thomas. Suddenly there's an opportunity for litigants and courts to say, whoa, wait a minute, let's see how clever we can be and come up with an argument that what everybody's always thought was true isn't true, which is sort of a strange way, in my view, for the law to operate. I do think it's quite inconsistent with the case you mentioned out of Alabama, Allen versus Milligan. In Allen versus Milligan, the court went out of its way to say there's 40 years of precedent here. The question was not whether there's a private right of action. The question was how that private right of action operates, or what it takes to prove a violation of Section 2 of the Voting Rights Act. The court went out of its way to say we are not upending 40 decades of precedent, 40 years of precedent. This is the way the law has been, and we don't think it's appropriate to change it. So while it didn't speak directly to the question that the Eighth Circuit has now ruled on, it certainly indicated a significant fidelity to an understanding of the statute that has been widespread, not just in the courts, also in Congress.
It sounds like there's a real circuit split here between the Eighth Circuit and the Fifth Circuit. So isn't this now present a question that the Supreme Court is going to have to resolve?
Yes, I think it does. The only possibility that would prevent that from happening would be if the Eighth Circuit Court of Appeals takes the case en banc, which would mean that the full court would reconsider the question the decision made by the three-judge panel. And there was a dissent, so there were two judges who ruled that there's no private right of action and one judge who dissented. I don't know how likely it is that the Eighth Circuit will do that. And on the assumption that it doesn't, or if it does take it en banc, that it comes out the same way, then yes, I think the Supreme Court will certainly have to take this case, and we'll have to settle the question once and for all. Based on the Alabama case, I think it's quite unlikely that the Supreme Court would affirm the Eighth Circuit.
That sounds right to me in terms of where the Supreme Court seems to be on this question. But in the event we're both wrong and the Supreme Court agrees with the Eighth Circuit and says no private right of action, can you just describe the implications of that? What would be left of the Voting Rights Act after that sort of decision?
The Voting Rights Act would be really astonishingly ineffective. We have already lost Section 5, as I mentioned before, the part of the Voting Rights Act that required covered jurisdictions to get permission before making changes in their voting and election systems. That was within hours after the Supreme Court issued that opinion in Shelby County versus Holder. States that had been required to get that kind of pre-clearance started enacting laws literally immediately that would never have been able to be pre-cleared and that have had the effect of making it harder for minority voters to exercise their rights. Section 2 was actually one of the reasons that the Supreme Court said, well, it's okay in that opinion. It's not the end of the world for us to get rid of the operation of Section 5 because there's still Section 2 lawsuits, and it specifically noted that those lawsuits can be brought by individuals, by private litigants. So on that point, the court itself has operated on that assumption. In the absence of private plaintiffs, the only way these lawsuits could be brought would be by the Department of Justice. And the Department of Justice just simply doesn't have the resources to bring all of the lawsuits that are brought by private plaintiffs. And under some administrations, really has indicated no interest at all in enforcing the Voting Rights Act.
So, Carolyn, if you and Greg are both right here and the Eighth Circuit Court of Appeals decision is overturned by the Supreme Court, does that settle all future disputes over Section 2 of the Voting Rights Act?
Well, it certainly doesn't settle all future disputes over Section 2. Litigants are going to come up with other arguments. There are always going to be questions about its scope and its application in different circumstances. But it would settle that question, whether or not there's a private right of action.
Our thanks to Carolyn Shapiro, co-director of the Chicago-Kent College of Law Institute on the Supreme Court. Coming up next on Bloomberg Law Show, we'll talk about a tax case that could have big implications for a future wealth tax. I'm Lydia Wheeler.
And I'm Greg Storr. This is Bloomberg.
You're listening to the Bloomberg Law Podcast. Catch us weekdays at 10 p.m. Eastern on Bloomberg.com, the iHeartRadio app, and the Bloomberg Business app, or listen on demand wherever you get your podcasts.
I'm Lydia Wheeler.
And I'm Greg Storr, in for June Grasso. Let's get now to that big tax case the Supreme Court is hearing over foreign earnings. It's being closely watched for its potential to upend other parts of the tax code and potentially affect a future wealth tax. Joining us to discuss it is Michael Rapoport. He is a Bloomberg Industries reporter covering tax. Michael, thanks so much for joining us.
Thanks for having me.
So tell us a little background about this case. Who are the people involved and how did they get to the Supreme Court?
Sure. The plaintiffs are Charles and Kathleen Moore, a retired couple from Washington State, and they are challenging a tax bill of $14,729 that they had to pay on the earnings of Kaizencraft, which is a machine tool company based in India in which they'd invested because Charles Moore was a friend and former colleague of the company's CEO. They contend that the tax that was imposed on them is unconstitutional because it was based on corporate earnings from Kaizencraft that were not actually distributed to them. The lower courts ruled against them, but they took their Supreme Court, and the High Court agreed to hear it.
What exactly is this tax? Is it new, and where did it come from?
The tax is known as the mandatory repatriation tax, or the transition tax, which was part of the Tax Cuts and Jobs Act, the big tax law overhaul back in 2017. This is a one-time tax on companies' accumulated foreign earnings. Big U.S. companies had been stashing their foreign earnings overseas for many years, rather than bring them back to the U.S. and have them taxed at U.S. corporate tax rates, which at the time were relatively high. What the 2017 law did, besides lowering the corporate tax rate, was to change the whole tax system so that all earnings of U.S. companies would be taxed going forward, no matter where in the world they were located. The mandatory repatriation tax was a one-time catch-up tax imposed on those accumulated earnings to make sure that they wouldn't be entirely free from U.S. taxation. But it also applies to people like the Moores, who had a significant stake in a foreign company, about 13% in their case, a 13% stake in Kaizencraft, and they were taxed on Kaizencraft's earnings even though they didn't actually receive any distribution of those earnings. That falls under the same mandatory repatriation tax, and the Moores claim that that's unconstitutional.
And so why do they claim it's unconstitutional? What's the argument that the Moores are making in this case?
This hinges on what's called realization. The Moores claim that it's improper under the 16th Amendment to the Constitution, which established the U.S. income tax, to tax them in this fashion because they didn't actually receive any distribution of those earnings. The government's response to that is that the tax is legal under the 16th Amendment, that it does in fact authorize Congress to tax a shareholder's share of undistributed or unrealized corporate earnings as income to the shareholders. In fact, the government says Congress has done so numerous times in the 110 years since the 16th Amendment was ratified. It's imposed taxes like taxes on companies' foreign income and partnership taxes that follow the same principle that you don't always have to realize income in order to be taxed on it, and the court has upheld those provisions in the past.
So what's the government arguing here then on the other side?
As I said, the government's argument is that the repatriation tax is legal, that in fact there have been cases in which unrealized income is taxable, such as taxes on foreign income, taxes on partnerships, and courts have upheld those provisions.
What are the key precedents here? It seems pretty remarkable that the 16th Amendment has been around this long and the court has never clearly answered what seems to be a pretty basic question about what it covers.
Well, one of the key precedents, certainly from the standpoint of what the Moores are claiming, is a case called Eisner versus Macomber, which is from 1920. The Moores claim that case rules out taxes on unrealized income. What the government says in response is that, that case was in a very limited context. It was limited to cases in which a company pays a stock dividend to a shareholder, and that the court has repeatedly refused to extend that principle beyond that limited sort of circumstances.
So if the court strikes down this tax, what are the implications for the rest of the tax code?
Well, the first and most obvious implication is if you strike down the mandatory repatriation tax, it could trigger enormous tax refunds for some of the giant multinational companies that had been paying billions of dollars in these taxes over the last several years, such as Apple, Microsoft, Pfizer. The government has projected that the tax would bring in a total of $340 billion over 10 years. So we're talking about something that could hugely benefit big companies. It could really blow a hole in government revenue. Beyond that, though, there's a lot of concern among people in the tax world, and it's kind of mushroomed ever since the court agreed to hear the case, that if you strike down the repatriation tax, it also calls into question other parts of the tax code that similarly are levied on corporate income that hasn't been distributed to the shareholder. The same principle behind the repatriation tax also applies in a lot of existing provisions in the tax code. So, for instance, you have taxes on foreign income, what's called Subpart F, which applies to taxes on certain kinds of income from the foreign affiliates of U.S. companies. GILTI, the tax on global intangible low-taxed income, which is the U.S. minimum tax on a company's foreign income. Taxes on partnerships, because their profits are taxable to the individual partners even when the earnings aren't distributed. Mark-to-market situations, taxes levied on the current market value of certain kinds of assets, like regulated futures contracts. Even something like taxes on zero-coupon bonds, which taxpayers have to pay taxes on each year, but don't actually receive payment until the bonds mature. All of those kind of fall under the same kind of principle as the mandatory repatriation tax. And there are other such situations. Paul Ryan, the former Speaker of the House, has suggested that a ruling in favor of the Moors could affect a third of the entire tax code.
So do the Moors and their allies acknowledge what you just said, agree with what you just said? Do they accept that this will have such a big effect on the tax code, or are they arguing, hey, this is actually a narrow case and there's a way you can resolve it in our favor without having all these big implications?
What the Moors and their supporters claim is that the mandatory repatriation tax is distinguishable from all these other provisions, and the details are very in the weeds and legalistic, but basically they claim that this is something separate from things like Subpart F and some of the other provisions, so that you can rule in the Moors' favor and strike down the mandatory repatriation tax and not have any of this other stuff affected. Some of the Moors supporters, the U.S. Chamber of Commerce, claimed in its friend of the court brief that the people who were concerned about this were engaging in hysteria and barely overstating the potential impact. What the people opposed to the Moors say, the people who want to see the court uphold the mandatory repatriation tax, is that it's not that simple. You can't really strike down one and preserve the rest. So if you strike down the mandatory repatriation tax, that really could have ripple effects and call into question a lot of these other provisions.
You mentioned that there's about $340 billion at stake here, and that, overturning this could really blow a hole in government revenue. Has the government talked about kind of what they use that revenue for and what, the implications could be?
Well, the government intended the mandatory repatriation tax as kind of a pay-for some of the other things that it was, some of the other changes that it made in the Tax Cuts and Jobs Act, such as lowering the corporate tax rate from what had been 35% down to 21%. This was intended, as I said, to make up for some of that lost revenue, and also to make sure that some of these accumulated earnings that companies had piled up overseas over many years wouldn't go completely untaxed when the government decided to change its tax system and tax all of U.S. companies' income going forward.
Michael, let's talk briefly, and we can continue after the break if we want to, about implications for a wealth tax. These are our hypothetical proposals right now, but what does this case mean for those proposals?
A ruling in the Moors' favor might preclude attempts to impose a wealth tax because it's based on the same kind of principles. A wealth tax would be based on the accumulated value of a wealthy person's assets. In other words, value that hasn't actually been monetized by the taxpayer. If you own a stake in a public company that has accumulated tremendously in value, that's paper wealth. You have not actually realized that income. You haven't sold the shares. You haven't received that as income. As long as you don't sell that asset, that means the accumulated value is an unrealized gain. And if the court strikes down the mandatory repatriation tax because it says you can't tax unrealized gains, that could mean you can't impose a wealth tax because it would tax unrealized gains.
Michael, tell us a little bit about this kind of side dispute, or maybe it's a central dispute, about Charles Moore's involvement with his company. Why is that a controversy, and how might it affect the case?
Charles Moore has portrayed himself and his wife as simple, passive outside shareholders in Kaizencraft, the Indian company at issue here, that they had no control of whether Kaizencraft distributed its earnings to shareholders. Since this case hinges on whether undistributed corporate income can be taxed, that could be significant. But what Charles Moore didn't say in his filings to the Supreme Court is that, and this is shown in Kaizencraft's corporate documents in India, Charles Moore was essentially a corporate insider there. He was a director of the company for 5 years. He received thousands of dollars in travel reimbursements for the company, even though he claimed in his filings that he never received any payments from the company. He advanced nearly $250,000 to Kaizencraft in the form of what was called share application money that was later refunded to him. He appears to have sold some of his shares to the company's CEO, who was, as I said, was a friend and former colleague of his. All this suggests that he would have had at least some sort of voice in whether Kaizencraft did, in fact, distribute its earnings to shareholders. Now, the question is, does all this matter to the case? And people in the tax world are kind of split about that. Some people think, yes, it does matter that the Moores haven't told the full story to the court, that it speaks to their credibility and to their portrayal of themselves as ordinary taxpayers in kind of a David versus Goliath situation. Other people contend, well, even if Charles Moore was more deeply involved with the company that he said, it doesn't affect the central issue in the case. It doesn't speak to whether the mandatory repatriation tax is unconstitutional. It doesn't speak to whether it's legal to tax income that the taxpayer hasn't realized. So these people think that at the end of the day, it does not matter to the ultimate outcome of the case. For what it's worth, the government has not shown any sign that it intends to make an issue out of this. So it's very possible it might not come up during the oral arguments on Tuesday. We don't know whether any of the justices have taken note of this issue, so we'll have to wait and see about that.
You mentioned earlier about the implications that this case could have on a future wealth tax. Can you talk about who has been calling for a wealth tax and kind of the history there and kind of why we don't already have that?
Well, this actually kind of started before the court agreed to take the case, because some conservative groups urged the court to accept and hear this case exactly for that reason, because they want the court to use this case to rule a future wealth tax off limits. Now, Democrats continue to press ahead with proposals for a wealth tax. The latest attempt was introduced in the Senate just a few days ago by Senator Ron Wyden, the chairman of the Senate Finance Committee. He insisted such a tax would be constitutional. President Biden has called for a wealth tax also, or a billionaire's tax, as they call it, where assets above a certain level would be taxed whether or not the income would be realized. As of right now, however, a wealth tax is still very much in the nascent stages. There's no indication that it's going to pass anytime soon. Congress is having difficulty agreeing on anything much these days. And even Wyden admits that a proposal of this nature probably wouldn't be acted on for some time yet.
Michael, we only have 30 seconds left or so, but do you have any strong feelings based on what the court has said or done in the past about how this case is likely to come out?
It's really hard to say. I mean, part of the reason that some of the people in the tax world have been trumpeting the potential implications of this so loudly is because they know that the justices, while they obviously are legal experts, are not tax law experts. Tax law is extremely in the weeds and detailed and complex, and they want to make sure that the justices, before they rule, are aware of the potential implications for the rest of the tax code. And it's really hard to say but how the court is going to come down on this. But this particular court has shown a tendency to not confine its rulings to narrow issues. So it's certainly in the realm of possibility that they could rule broadly in this case, and if they do in fact rule in favor of the Moors, issue something that could have significant implications for other provisions in the tax code.
That's Michael Rapoport, a senior reporter at Bloomberg Tax and Accounting. Thanks so much for joining us. Well, Greg, one thing we didn't chat about with Michael is the controversy here involving Justice Alito in this case, over one of the attorneys that's actually arguing, I think David Rivkin, he's going to be before the court. Can you talk about the relationship with Alito there and what's going on? Yeah, really unusual situation. David Rivkin, a well-known conservative lawyer, co-wrote 2 Wall Street Journal articles, opinion pieces, or with an opinion writer at the Wall Street Journal, in which it basically gave Justice Alito a forum to say some things. And he talked about the leak of the ruling in the abortion case. People have said that was an inappropriate thing to happen, and Democrats have called for Justice Alito to recuse from this case because of David Rivkin's involvement. And then Justice Alito, back in September, put out a statement in which he said, I'm not going to recuse. There's nothing out of the ordinary about these interviews, nothing to see here. And so every indication is he is going to participate in this case. Wow, that's really interesting, especially given all the ethics controversies. And that does it for this edition of the Bloomberg Law Show. I'm Lydia Wheeler. And I'm Greg Storr. This is Bloomberg.